Complex environmental and toxic tort cases can be a major operational headache for plaintiff law firms, especially habitability and mold exposure claims. These cases often arrive messy, document-heavy, and scientifically underdeveloped. A potential client may have a compelling story, but the evidence is scattered, the causation picture is unclear, and the firm has to decide whether to invest time and money before knowing if the case can truly be supported. That intake and vetting process can quickly become a serious drain on firm resources. Today, we'll show how MCC helps streamline that process. We'll cover how your firm can save time, what MCC does, our 23 vetting system, the role of non-recourse funding, the 3-phase workflow, and how our case summary reports and expert support help move cases forward. Okay, so let's address the elephant in the room. The upfront financial and temporal drain these complex habitability cases place on you. Historically, when a messy mold narrative lands on your desk, your team suddenly has to play detective, scientist, and medical coordinator all at once. But here is the absolute best part. Literally, the most crucial thing to know right away. Utilizing a coordination layer to handle all that upfront heavy lifting costs your firm exactly $0. To actually take advantage of that $0 model and maximize your time, we need to clear up who MCC is, what it actually does, and where it fits in the legal ecosystem. First off, MCC is not a competing law firm. They don't practice law, and they definitely don't step on your toes regarding litigation strategy. Instead, think of them as your dedicated evidence gathering and coordination layer. They handle the logistical nightmares, booking environmental testing, coordinating medical workups, and engaging the right experts, so you get to focus exclusively on what you do best, prosecuting the case. So, how do you separate a noisy complaint from an actual winnable case? Well, before a file ever even makes it to your desk, MCC puts it through a brutal 23 expert qualification system. This is an absolute game changer for your intake department. They're looking for environmental red flags like visible growth or failed remediations. They check medical flags like pediatric occupants who are escalating healthcare visits. Finally, they provide the attorney with a detailed and comprehensive breakdown of the potential plaintiff's situation. Notice, lease agreements, and everything else required for the attorney to conduct a true legal review. The bottom line? You only see a referral after it's been vetted by qualified and experienced experts and documentation, not just a client's narrative. You're probably wondering who pays for all this upfront science without draining your firm's war chest, right? Let's look at the division of labor here. MCC handles the intake and orchestrates the hygienists and doctors. You handle the conflict checks, retainer agreements, and the actual litigation. And the funding? For qualified referrals, a non-recourse funder steps in and covers phases 1 through 3 via a direct disbursement to MCC for a pre-approved scope of work. MCC's network of funders handles this non-recourse advance. And here is the kicker. This funding is tied directly to the client, not to your law firm. And because it is non-recourse, if the case goes south and there's no recovery, the client owes absolutely nothing. It's a brilliant setup because it completely de-risks that expensive early investigative phase for both your firm and the client. Let's crack open the actual scientific workflow MCC runs once that non-recourse funding drops. It is a highly structured 3-phase march. Phase 1 establishes the environmental contamination, getting certified lab results, a strict chain of custody, and the industrial hygienist report. Then, Phase 2 shifts into medical discovery, ordering exposure-informed lab panels for the clients. Finally, Phase 3 ties the whole thing together. A toxicologist links the environmental findings directly to the client's biomarkers, and a medical doctor provides a concrete, specific causation opinion. The whole process takes about 10 to 11 weeks from start to finish, and what it does is essentially take a chaotic, messy story from a stressed client and transform it into a highly structured, scientifically backed legal asset. You don't have to chase down labs. You don't have to stress over chain of custody. And you certainly don't have to play schedule coordinator for a toxicologist or medical doctor. MCC manages all those milestones for you. So, at the end of week 11, we arrive at the ultimate deliverable. Your firm gets handed this, a single litigation-ready case summary report. This takes everything out of the realm of theory and drops it onto real, highly organized paper that is built specifically for quick, seamless attorney review. And this report doesn't mess around. It gives you highly detailed, extremely specific causation opinions. We're talking exact toxicologist correlation reports that link pathogenic molds and bacteria directly to biomarkers in the occupant's body. And right alongside that, you get specific ICD-10 diagnoses from the medical doctor, things like mycotoxicosis, contact with toxic mold, fungal sinusitis, and chronic cough. It's all right there, ready for your team to run with. This entire package is engineered to slot instantly into your demand packages and early discovery strategy. You get everything, literally. Summarized environmental sampling, chain of custody lab references, medical treatment plans backed by clinicians, estimated future medical damages, and all the foundational exhibits you need, like leases and notices. They even throw in a concise chronological timeline of events to make your life easier. Are you ready to spend less time vetting and way more time litigating? By partnering with MCC, you literally eliminate your biggest operational bottlenecks. You get de-risked files that are fully validated by top experts, and you bypass the upfront funding nightmare entirely. It empowers you to get back to what you're actually here to do: win cases. How much bigger could your docket get? And how much more profitable could your firm become if you never had to front the risk, the time, or the sheer chaos of a complex, toxic tort investigation ever again? The next move is simple. Utilize MCC. Let the experts validate the file and start turning complex mold claims into litigation-ready opportunities.